All right, everyone. Welcome back. Get started. It's a pleasure to welcome you to our panel on provision and punishment. My name is Andrew Crespo. I'll be moderating this panel, and I'm delighted to introduce the three presenters. I'm going to introduce them in the order in which they're going to talk about the papers and remarks that they've prepared. Starting immediately to my right, we have Professor Jasmine Harris, who's Professor of Law at the University of Pennsylvania Carey Law School, where she studies and teaches on law and inequality with an expertise in disability law, anti-discrimination law, and evidence. Her scholarship examines the relationship between law and social norms, specifically law's capacity to shift social and cultural conceptions of disability that impede the democratic process. Sitting next to Jasmine is Professor Jamelia Morgan, who is joining us from, who just recently joined the faculty at Northwestern Pritzker School of Law. Her scholarship and teaching examine the development of disability as a legal category in American law, disability and policing, overcriminalization, and the regulation of physical and social disorder and the constitutional dimensions of the criminalization of status. And finally, we have Professor Jonathan Simon, who's a professor of law at Berkeley, where he teaches courses on the criminal legal system and movements to abolish it. His scholarship concerns the role of risk and crime as frameworks for governing modern societies. Sort of seated them with Jamelia in the middle, bridging between the disability field and the criminal field, and that's the order that we're going to go, starting with Professor Harris.
Great. Well, thank you, Andrew, and many thanks to the organizers of the gathering, especially a quick note of thanks to Sanjay Jolly for organizing and working with us in the last couple of months to make this a reality. And so the project that I'm going to share with you today is an early stage project, and it's tentatively called Disability Exceptionalism and the Political Economy of Conservatorship. The article, as I said, is very much a work in progress, and so I welcome comments, feedback, thoughts, questions, cautionary notes, anything that you may have to say. Many of you here are likely to know what conservatorship is, but just in the interest of making sure we have a shared working definition, conservatorship or guardianship, as it is also known, it is a decision-making, or rather substitute decision-making device and vehicle for people deemed incapable of making decisions, or a host of decisions that the law cares about. So that includes contracts, including entering into marriages, making healthcare decisions, and exercising the duties and privileges of citizenship, including voting and jury service. Historically, with respect to adults, there were two general forms of this. There was control over the person, most often referred to as guardianship, and control over the estate, most often referred to as conservatorship. And because state law governs these questions, just to situate us on the L part of LPE, the state systems vary. So they may use different terminology and different structures, from plenary forms that are like on and off switches, which combine the two, that is to say control over the person and control over the property or the estate, and grant the substitute decision maker control over both. Two particular states that have moved toward limited conservatorships or guardianships that enumerate particular powers and decision-making authority for the conservator. Conservatorship has recently garnered national attention, and I'm going to pull up my slides just to give you an image here. Let's see. Okay, and so many of you will be familiar with these images. It's garnered national attention when we've talked about the conservatorship of Britney Spears. And what I want to do is to situate this conversation by talking about conservatorship and the current debates around conservatorship. And they tend to fall into three camps, three separate camps. The first camp is the celebrity camp. You've got a picture of Amanda Bynes and Britney Spears. It's almost like one of the top magazines have come to life in this slide. But basically, the notion is that conservatorship is inappropriately applied. It is fundamentally a legitimate institution that is over applied. And there are two kind of fundamental debates here within this camp. It's Brittany is not a person with a disability, and so it focused on her status, not as worthy of that label, or that Brittany is in fact a person with a disability, but she's just not the right person with a disability for this system. And so the notion is it's a system that's legitimate, bottom line, but not for her. And so at the end, this cashes out with this group calling for reforms of the system, for greater transparency, accountability, et cetera. The second camp, as evidenced by some of these pictures here, you may be familiar with some of these documentaries, including The Guardians, and Netflix had the series Dirty Money. And there is another one I care a lot about, guardianship abuse in the elder law context. And this is fundamentally driven by a concern, again, here, the legitimacy of the institution is not questioned. We need this institution as the party line, but in fact, it is something that requires significant reform, greater accountability, greater transparency from overreaching individual bad actors. Camp number 3, again, these camps, there may be overlap. The media often conflates these different camps. For our purposes, I'd like to keep them separate. Camp number 3 is a camp that's motivated by people with intellectual and developmental disabilities. And the notion is that here, not all people with intellectual and developmental disabilities need conservatorship or guardianship. The move here conceptually, again, legitimate institution as a general matter, but is overused. And in fact, courts, because of disability and perceptions of disability historically, have reached for this as the first order of business, as opposed to less restrictive alternatives, such as supported decision-making that I have listed at the bottom. And so the 3 camps basically come together around a reformist agenda, and a very similar reformist agenda at that. And, you know, the thesis of this paper is that these contemporary debates are looking at a system that is inherently legitimate and capable of reform. But I want to say, through my work here, is that conservatorship has always been fundamentally about political economy. And in fact, it's been about power distribution, and definitions of care and protection have masked its racial, capitalist, and extractive roots. That is the fundamental premise behind the paper. And I talk about in the draft around some of these core assumptions. That is to say that in these debates, the assumption is it's not going to be revolutionary to many of you in the room in terms of the principles, that this design around conservatorship and guardianship is in fact a feature, not a flaw, and that this system is fundamentally flawed. And that one of the interventions I want to make here is to say that the way in which conservatorship continues and has continued over time, and I'll talk about some of the history in a minute, it's been able to do so through a concept of disability exceptionalism. That is to say, this premise that disability is rare, it is a legitimate ground for state regulation. And in fact, the state of the law is such that it's able to mask what it does, because as a matter of constitutional law, we have principles that were found under Cleburne versus the Cleburne Living Center. And in that case, the Supreme Court said disability is not a suspect classification, and therefore it is entitled to rational basis review, great deference to states. This is a legitimate ground to regulate. Well, the research that I'm doing is looking back in time at the history of conservatorship, and again, arguing that we miss fundamentally these racial, capitalist, extractive roots of this institution. And when we do that, we miss everything. We miss the fundamental assumption that this institution is capable of reform rather than abolition. So just a couple of things to highlight in the research that I've seen so far. I've gone back in time and looked at native takings, early native takings around for example, in Oklahoma. And you have, here's a quote: "Let the oil be discovered by an Indian allotment, and a member of the profession will promptly file a petition to have the individual declared incompetent and to be appointed a guardian. So when we've talked about these historical moments, and there's literature certainly out there on this, but we haven't talked about it from a disability perspective. That is to say, we've said these institutions, much like the debates we're having now about Britney Spears or elder law, et cetera, these institutions are inherently being misused. They are being misapplied, rather than to say, as a matter of disability and from a disability perspective, using the disability label, even for people with the most severe disabilities, this institution is fundamentally flawed. And not only flawed, but it's operating as it should, and therefore we ought to be considering abolition. So I do some research on the native takings, reframing it from a disability perspective and really pushing on this notion of guardianship and highlighting several stories there. I just want to show you the second example that I've been kind of looking at, which is the institution of guardianship in the antebellum period. And I've been doing some research around when, in fact, guardianship began to become more developed, when I would notice guardianship legislation start to pick up. And in fact, it corresponds, not surprisingly, with the prevalence and the increase of freed Black persons in the South. And so as there was a critical mass, there became a question of how, in fact, do we control this population? It was fundamentally about control, but it was also about extraction. And so the tie between the free Black person and the court system was very key to understanding this. And so here you have an entry from Sumter County in South Carolina, and it talks about certifying, I have known James Gaiman, a free man of color, for 15 or 20 years. This is a petition to the court. If you were a free Black man in South Carolina, you had to register with the court for a white guardian. You needed to have a white person as your effective actor and representing your personhood. And so I want to just read a quote here from the Georgia statute. The Georgia statute, for example, says all free persons of color must be registered annually by the clerk of the inferior court, for which they pay an annual fee of 50 cents. Now, this is in 1853. 50 cents was a pretty hefty fee. So again, thinking about the kind of extraction model, they had to obtain the certificate of freedom and select some white man as a guardian. And the court gives meaning to this in Georgia, and the court says, whereas we maintain that the status of the African in Georgia, whether bond or free, is such that he has no civil, social, or political rights or capacity, whatever, except such as are bestowed upon him by statute, that he can neither contract nor be contracted with, that the free Negro can only act by and through his guardian, and that he is in a state of perpetual pupillage or wardship, and this condition can never change by his own volition. It can only be done by legislation. And so the types of activities that you needed a guardian for were basically everything, but the literature at the time talks about the need for guardians to control movements. So when there was organizing happening with free Black people at the time, the use of guardian as a form of control was very much a part of what was happening. There were edicts to the guardians to revoke their tickets that allowed free persons to move and move in public spaces. There was also the use of guardianship through, like I said, through the court system directly, and a positioning of guardianship as a mechanism of due process. And so what you see at the time is this language of due process being afforded to free Black persons by allowing them to have a guardian as a representative in court. And what the conversations are very much like, this is a device of liberty. We are extending this device of liberty and protection for individuals who are incapable of protecting themselves, specifically from kidnapping, in terms of status, and thinking about if individuals were, Black individuals were kidnapped and tried to be forced back into slavery, what they could do is one specific use, and there's a lot of literature at the time about how this was the use. The reason for guardianship was to go into court and to have your guardian say, no, this is a free person, and litigate your rights. Although what they don't say is that the rights were litigated in a sense, not through the words of the individual, because the individual who was brought before the court could not testify, and the individual faced significant fees and penalties and imprisonment if, in fact, they lost. So if they dragged in someone else to kind of challenge the nature of their status, and there was a white slave owner who said, this is in fact one of my slaves, and the court says, no, you actually, you are a slave and legitimately the property of this white slave owner, then at that point in time, the free Black individual would have to bear the costs of the proceeding and be brought into slavery again. And so there was some financial costs to exercising that process as well. So the history is rife with examples like this, and I'm working my way through it, but I wanted to just kind of fast forward quickly and I'm going to turn this off. And I will be fast. And to just kind of turn to what we're seeing today. So in the conversations that I put up on the board in terms of the contemporary debates, what you don't see are the examples of individuals in Alameda County. And I've been spending a lot of time sifting through the files that are public, the ones I can get my hands on in Alameda County. And there's stories essentially where there are Black families who've amassed property in Oakland, at Lake Merritt, in the area in Lake Merritt. And when the older matriarch or the patriarch is, they're living in their home and they're living in the community, they're being brought into the courts through this guardianship process, and they're being dispossessed of their property. And so there's more than one example of that pattern and practice in terms of actual property extraction that's happening today. And it's not just in Lake Merritt, it's not just in Oakland, it's all over the country. And it's people of color. And the story is often about white individuals who are propertied individuals. And so one of the things I'm trying to do is also connect the stories of what's happening today in terms of the school to guardianship pipeline. So individuals who are in schools who reach the age of majority and get their educational rights are often given, when they get those educational rights, parents are told you have to file for guardianship or conservatorship of your child. And this often happens in schools in poor Black and brown neighborhoods. And so there are all of these examples of using guardianship and conservatorship as vehicles for power shifting, because what happens is once individuals are under these systems, it's nearly impossible for them to get out from under it. And so you have someone like Britney Spears with all the power and money and whiteness in the world who is able to be under the control of a system for 13 years without people looking into it. Imagine someone without the wealth and the platform, et cetera. So the project is really trying to connect and both mine history and connect the current instances and talk about how this institution itself is inherently problematic. The debates are missing this and why we cannot have these debates unless we look at this history. And so I will save some of the more specific examples for the Q&A and pass the mic.
All righty. Well, it's really an honor to be here. Can everyone in the back hear me? Great, thank you. I am absolutely delighted to be in conversation with so many of you. I'm also sort of seated between two scholars who have influenced me greatly. So I am a little bit nervous, but also incredibly grateful. So I'm going to talk a little bit about my current project, looking at mental health crisis response. There is an article. I'm going to maybe talk for about 10 to 12 minutes because I really want to dive into the discussion with my co-panelists and the rest of you all. All right, so here goes. So in late November 2022, New York City Mayor Eric Adams issued a directive ordering New York City police, fire departments, and mobile crisis teams to increase their efforts to involuntarily transport and hospitalize people found on the streets and subways determined to be quote unquote mentally ill. The directive instructed first responders to seize and transport people who, quoting from the directive, appear to be mentally ill and display an inability to meet basic living needs, even when no dangerous act had been observed. The directive is a vast expansion of state power to arrest and extends the state's power to initiate emergency psychiatric holds well beyond the usual state law requirements that individuals pose a danger to themselves and others. Referring to what he termed the crisis we see all around us in his address to City Hall, Mayor Adams vowed that going forward, we will make every effort to assist those who are suffering from mental illness. Publicly, Adams has explained that the directive was for the safety and benefit of people with severe and untreated mental illness, because, as he said, the very nature of their illnesses keeps them from realizing they need intervention and support. Since entering office, Adams has made clearing homeless encampments a priority and has touted the forcible detentions and involuntary hospitalizations of people within these camps as part of what he called the moral obligation of the city of New York. The foot soldiers for this program, EMS staff, medical personnel, and the police would receive training immediately, according to Mayor Adams, to ensure compassionate care. The directive was met with swift condemnation from disability rights groups. New York lawyers for the public interest, representing a coalition of disability rights activists, sought a temporary restraining order seeking to halt the implementation of the policy. In November, Jumaane Williams, the city public advocate, released a report criticizing the mayor's efforts to provide care for people with psychiatric disabilities. Among other things, the report found the mental health program had lost considerable funding and that Mr. Adams had been over-reliant on the police. And as to the mayor's claims regarding immediate training, reporting from the New York Post indicated that at least at the end of November 2022, NYPD officers still had not been trained on implementing the directive or on crisis intervention in general. At the other end of the country and at around the same time, Governor Gavin Newsom signed the Community Assistance, Recovery, and Empowerment Act. The quote unquote CARES Act permits family members, first responders, and others to petition a judge to drop a treatment plan for up to a year for someone diagnosed with certain mental disabilities, including, and as expressly identified in the law, schizophrenia. Treatment plans could include medication, housing, and therapy, yet individuals who refuse are at risk of being placed under conservatorship and forced by court order to comply. Here again, disability rights group within California and nationwide rallied against the law and issued a public letter condemning the law, emphasizing the threats to liberty, autonomy, and self-determination that it posed. Newsom, for his part, expressed little concern for the civil rights violations. Newsom said he was quote unquote exhausted by the arguments from civil liberties groups and clapped back, stating their point of view is expressed by what you see in the streets and sidewalks all across the state. Though the details of these laws differ greatly, their goals are clear: remove individuals labeled as seriously mentally ill from public spaces. Both laws threaten to scale back decades of progress made by people with mental disabilities, including many psychiatric survivors of institutionalization, as well as the disability rights and disability justice movement goals of self-determination, independent living, and liberation. How can we make sense of these dramatic expansions of state power targeted on disabled bodies and minds, and the relative lack of public awareness or outrage, of course, beyond disability rights movements? What allows disability as a category to facilitate such vast deprivations under the guise of treatment and care? Indeed, how is it that in their appeals to the public for support for their programs, both Mayor Adams and Governor Newsom leaned into discourses of care, while in the same breath advocating for arrests, more restraints, and other punitive practices that look more like punishment than treatment? What makes disability categories such productive tools in efforts to manage and police marginality and precarity? In my remaining minutes, I'd like to offer some preliminary thoughts on these questions. So recognizing the various societal meanings of disability, what I'll refer to here and in the literature we see this as disability constructions, allows us to surface the ways that shifting social meanings of disability can be deployed to pathologize disabled, quote unquote, others, even while claiming to protect them. Disability constructions rooted in the charity or pity models of disability, which paint disability as a tragic object of pity, can be deployed to present superficial appeals to moral values, thinking back to Mayor Adams' statements. These disability constructions harken back to an era where reformers sought to address a similar problem, namely the problem of mentally ill individuals in public spaces, whether they were found wandering in public spaces or identified as quote unquote dangerous lunatics, to quote from a 1829 New York state law. These reformers called on the state to institutionalize disabled people in large state-run congregate facilities. These policies led to horrific abuses and indeed spurred the deinstitutionalization movement. Disability constructions that frame the myriad social problems that contribute to precisely why people experience mental illness are in public spaces in the first place, as predominantly problems of treatment and care, can be traced to the medical model of disability. The medical model of disability frames disability as a health problem requiring treatment or cure. It does not recognize disabilities as differences in bodies and minds produced in large part by societal barriers that may do more to exclude or impede the thriving of people with disabilities than the impairments linked to the disability themselves. Beyond this, medicalization adds legitimacy to and stifles dissent and counter mobilizations by portraying clinical assessments as objective, scientific, and definitive. The narrowness of the medicalization frame in turn facilitates a narrowing of the scope of the relevant social problem. Here again, the presence of people who are labeled as mentally ill in public spaces, and thereby narrows the range of adequate remedies to solve the problem. That is to say, it takes off the table deeper structural and radical reforms that might actually destabilize the social order by dramatically shifting social relationships, investments, and priorities. Disabilities produced by the violence of neoliberal policies, divestments from welfare, public housing, failures to invest in at-home and community-based services, which have produced a workforce of personal care attendants who are overworked and underpaid, are masked, rendered illegible in dominant discourses of behavioral health and mental health crises that pathologize. Finally, disability constructions can even serve to prop up and support and provide support, that is, for the well-worn and tired liberal reform refrain that calls for more punitive measures and carceral approaches to respond to societal problems, whether rising crime or encampments, despite the proven ineffectiveness of these policies. Focusing on the various disability constructions supported by narratives, myths, and rhetorical appeals is a lens through which to destabilize status quo arrangements and delegitimize discourses that seek to use disability labels as the terrain upon which to exercise, expand, and entrench state power. Movements and formations, Project Let's, Fireweed Collective, Us Protecting Us, contesting these status quo arrangements are mobilizing across the country, seeking and winning reforms to decouple police from crisis response and forming mutual aid organizations to respond to loved ones and neighbors experiencing mental crisis and other personal crises. In so doing, these movements are rejecting neoliberal approaches to behavioral health that have consistently failed to produce significant and sustained investments in robust behavioral health systems, despite the demands of the earlier deinstitutionalization movements and even the passage of the Community Health Mental Health Act almost 60 years ago this year. They have named hospitals as carceral spaces and forcible treatment as punishment. They have demanded more than rights or quote unquote care. They have called for state and non-state arrangements and relationships that promote human flourishing. Finally, these movements have recognized the limits of rights and resisting ableism by acknowledging the work disability constructions do in justifying law and order discourses and punitive liberal lawmaking practices. As the Adams and Newsom proposals demonstrate, disability constructions can be deployed to dispossess people with disabilities of the rights in the most brazen ways. Current movements have sought, as the psychiatric survivor movements before them, to shift power away from the police, medical professionals, and other helping professions, and to individuals with lived experience. They have worked to shift power through mutual aid, consistent with abolitionist and disability justice practices, through reconfiguring social relationships and bonds. I think their insights bring value to any LPD methodology and approach. Thank you.
Greetings from the left coast, everybody, and please, Andrew, let me know if I get anywhere near my time limit. I'm a criminologist, so my loyalty is to order, not empirical. So my colleagues have been admirably focused in their research and efficient in their presentation. I'm totally unfocused in the sense that I'm going to try to give you a history of everything to do with the carceral state for about 1,000 years, but I will try to follow them in being admirably efficient to talk about it. So I take it that you will agree with me that if political economy is promising for those of us struggling to make a more just society, it's not because it offers universal laws of history that guarantee us a happy ending, but rather the tools to consider how the highly contingent historical struggles that have shaped the legal system and the carceral state in particular, that have created structures of power and meaning that still live with us today. I mean, history is not an arrow shot from the past that sort of hits the present and that's it. It's a continuing process of sort of reinfusion. So I try to tell my students when I teach what this is essentially a summary of a semester-long course on the history of the carceral state. That when we look at the modern carceral state, it's like looking at a European cathedral. You're seeing a structure that was built over centuries using different principles of architecture, sometimes different theologies actually embodied in it. And yet we have to make sense of it and live with it today. Fortunately, I would say maybe compared to those areas of law dealing directly with capital and labor, perhaps no area of law has received more careful attention from sort of political economists over time than the carceral state. And let me just remind you of some of those. So, focusing on the sort of what I call the arc of discipline, closely associated with the creation of what sometimes is called primitive accumulation, capitalism, slavery, the formation of a working class, those themes. Marx himself writes about this in terms of the law of theft. You get Yevgeny Pashukhanes, the Soviet theorist of law, who offers a really still very insightful analysis of how modern punishment attempts to create a bourgeois wage structure in the criminal form. You have Ruscha and Herkheimer, the Frankfurt School theorists who studied how the prison system had sort of recognized the value of labor, but then the conditions in prison trapped essentially the vicissitudes of the labor market. And then closer to our own time, Michel Foucault's Discipline and Punish, Molosi and Paparini's The Prison and the Factory. All of these, in a way, were focused on the relationship of the prison and the various disciplinary projects associated with it to the construction of capitalism in its early stages. More recently, the period we might think of as mass incarceration, I'm calling it for now at least the arc of expulsion, where we've had, again, tremendous help from scholars like Ruth Wilson Gilmore in Golden Gulag or Loic Bacan in Punishing the Poor, which have essentially examined mass incarceration as a response to a fundamental redistribution of poverty and new strategies for controlling it. Often those are the two data points we hit or the two time points we hit. More recently, a lot of us have belatedly come to realize how important the eugenic arc is, the period we sometimes call the progressive era, but really should be called the eugenic era. This is certainly the moment that disability and crime get inextricably interwoven with each other in a way that resonates in both of my colleagues' papers. And it's really hard to understate the transformative power eugenics have, particularly in this country, over American law. Just think of prohibition, mass sterilization, the end of immigration from Asia and most of Europe. I mean, the constitutional amendments to accomplish these things like prohibition. We probably haven't seen an era with quite as much transformative and pernicious effects as these. I would argue we need some late medievalists to really study the beginning of this all, which is what I call the arc of sovereignty, where the birth of public punishment, the removal of crime from the ownership of its victims and their communities to a form of state power. It's hard to imagine colonialism, capitalism even developing without that kind of strong state structure and the ability to confiscate estates, the ability to make law and use the police power broadly. For today's discussion, though, I really want to focus at sort of the other end of this chart on what I call the myths about punishment, or perhaps the carceral church, because it seems to me these myths have not so much replaced each other any more than the institutions have replaced each other, right? If you look at these institutions that, and I'm just listing the most typical of the period, the only one that's dropped out to my counting is scaffolds. We don't seem to publicly execute people quite as much anymore, unless you count videotaped police murders in the street as the equivalent, which we might want to do. But, and here I want to say that those of us in political economy need to pay attention, not just to Marx, but to Durkheim, because in so many ways, the carceral state presents a religion of the state that is a tremendous source of re-legitimation, both for it in particular and the larger state as a whole. Let me just say, I'm going to use the term carceral state, but I get it that there's not just one carceral state, even say the US carceral state or the Massachusetts carceral state. It's an incredibly fragmented system, but I need as much saving of time here as I can get. So let me just highlight what I consider the 4 most germinal punitive myths, each of which kind of arises as an ideology as part of the struggle really to expand the carceral state or establish it in the original sense over tremendous resistance. And we tend to forget how much resistance has shaped the way the carceral state comes down. It's never been popular. It's always had to be sold as something that it wasn't in order to get it through. And I would argue that all these but one perhaps remain tremendously resonant for many Americans and really people around the world. These will be familiar. One of them is the myth of repayment. When we say somebody's paid their debt to society, we pay our debt to this tremendously misleading myth that somehow a crime creates a debt to the state, to society, and that punishment is the unique currency in which that has to be paid. And if it isn't, you get a kind of fiscal crisis of legitimacy where the state has sort of lost its credibility, right? You know, just pick up today's papers and read liberal Democrats saying, of course, Trump has to be held accountable. Of course, every crime has to be matched with a punishment. We believe in that. And in many ways we do. What about the idea that punishment reform, so associated with the arc of discipline, the birth of the penitentiary, asylum? Again, amazing how tenacious the hold of this is. And I'm not here saying that nobody's ever reformed as part of the process, but it's usually through their own efforts or peer efforts. And yet even today, reform remains, and I'll get back to this, one of the most attractive legitimizing frameworks for the carceral state. We may think we've come some way from the sort of Jacksonian image that forced labor, you know, based on a slave discipline model is the best reformative measure. But in recent studies of things like drug courts and whatnot show that when people are treated, they're often sent off to warehouses to do unpaid labor. I guess that will help them get control of their drug habits and related illness. The myth most associated with the eugenic age, and it certainly has never lost its appeal, is the idea that punishment allows us to remove the irredeemably dangerous from among us. And originally that was supposed to be a few people, and we would reform the others. In more recent times, it's become, I think I lost my internet connection here, but I'll forge ahead. The one that I associate with the contemporary period, I call reinforcing, the idea that punishment can help reinforce the safety of safe neighborhoods, the viability of viable communities, and that it's sort of very associated with the broken windows policing model, but it has its equivalent in the prison side of the punitive state. I'm not quite sure. Should I try resharing again? Let's see. Take a moment to that. Well, I'll ignore that for the moment. I'd be happy to send what essentially is this comic book to you by email. Oh, there it is. All right. So and the last one, which isn't really time dated because it's run through this whole period, is the racial threat myth. And this is the idea actually captured by Hubert Blaylock's famous racial threat hypothesis that Black demographic or political power is itself a threat to public safety and must be checked by increased police and prisons. Now, a question is, what's the value of myths? And I want to just point to two things. One is, turns out that these carceral expansion campaigns are long-term campaigns. It takes a long time to establish them, and you need multiple hooks to keep constituencies on your side. Think about prohibition, right? It was incredibly controversial, but it held together for about a 20-year period, which led to the first kind of wave of mass incarceration in the US. To sell prohibition or resell it, you had to go back to the myth of reform, that the idleness exacerbated by alcohol was a big source of crime. You had to embrace the new myth of eugenics, that alcohol was a form of racial poisoning as well as a source of degeneracy. In the more contemporary period of mass incarceration, again, we saw many different constituencies brought into the pro-carceral campaign. Feminism, some parts of the Black community and the civil rights community. You need different myths to do that. But I think the other, what I want to focus on today is they're really helpful when the carceral state comes under attack. Because most of these myths can be effectively invoked with what my late colleague Lauren Edelman would call symbolic structures. You don't actually have to do anything really big or expensive. You can do things like rename the California Department of Corrections, the Department of Corrections and Rehabilitation, as we did under Governor Schwarzenegger in 2007. So let me just briefly remind you that we actually had a carceral crisis of legitimacy in the last decade that involved both policing and prisons. The prison side, I think, in many ways was manifested in the remarkable hunger strikes that swept through the California prison system in 2011, and again, on a bigger scale in 2013. The Supreme Court case Brown versus Plata, which was actually a result of 20 years of turmoil and toil by imprisoned people to make their healthcare, a subject of legal review. Policing, way before George Floyd, certainly by the Ferguson moment, in many respects, by really the mid-2000s, it was growing popular dissent against the violence of policing in our streets. I wrote this book in 2014, Mass Incarceration on Trial, because I thought, while we can't look to the Supreme Court to save us, that Brown versus Plata signaled perhaps a collapse in the legitimacy of the carceral state that we could take advantage of. But we are now in the midst of a carceral recovery. And I just want to devote my last few minutes to talking about how these myths play a role in these carceral recovery. So the prison system, just to remind you a little bit, as Ruth Gilmore summarized this so well in Golden Gulag, back in the 70s, California by law stripped rehabilitation out of the system. We literally said in the statute, the purpose of prison is punishment. But when it came under extreme pressure from the courts and from political movements in the audience, what did we do? Well, we decided we were back in the rehabilitation business. It started with Schwarzenegger's very symbolic renaming. By the time Governor Brown was back in the State House for his second term, he was fighting off the Supreme Court's mandate, insisting that California had some of the most rehabilitative prisons in the world, which was just purely delusional. And then Gavin Newsom most recently has proposed turning San Quentin, our oldest prison, into a Norwegian-style rehabilitation center. And while the great Bill Keller has recently embraced this in a New York Times op-ed, I could, it would take me more than we have this evening to explain all the ways in which that's an absurd idea that just ignores the carceral landscape that has shaped California. Just to give you a flavor of it, the average prison size in Norway is 250 people. And when you get up toward 1,000 in their system, it doesn't look good. I mean, those prisons start to look more like California prisons. Our smallest prison, 2,500, I think, at the smallest. In any event, Newsom, who's eventually a secret here, is going to run for president and wants to be able to show that he's got a liberal solution to crime and mental illness, as both my colleagues pointed out. There's also a tremendous role for the repayment myth. It's interesting that during the reduction in the carceral population to conform to Plata, the state's plan made sure that not a single imprisoned person left prison early. It was all going to be done through diversion of future people. And recently, with lethal COVID spreading through the system through deliberate indifference by the prison managers, the governor again implemented only the most modest, I think it was imprisoned people coming up on 100 days of their release date could get out, not the people who were most at risk of COVID. And of course, the idea that most of the people in prison are dangerous remains behind every discussion of the parole process, et cetera. Let me very quickly get to policing. And again, policing is local, so the carceral state and police jurisdiction is a much more variegated picture. But recently, as I'm sure some of you know, we suffered a big backlash and a big loss in the removal of perhaps the most progressive prosecutor type in the country, Chesa Boudin. It was, a very bogus, flawed election that the national media has turned into a sort of plebiscite on reform. But even ignoring that, it's clear that the police, and they were the main engine behind the campaign against him that began the day after he got elected. They were essentially driving this, and they did it largely by focusing public anger about homelessness, which you might say, nothing to do with the serious crimes that people are talking about. But again, if you go back to that broken windows model, that reinforcement model, letting those little things go is the first step to having your neighborhood become a bad neighborhood, a high crime neighborhood. So there was a lot of focus on that. There was a lot of focus on the ability of police to remove the dangers among us. And in the campaign, it was largely focused on repeat fentanyl sellers with the new face of super predatorness, you might say. And of course, the racial threat hypothesis. And that came down to this. Chase is just too concerned about Black people. He obviously can't protect our safety if he's actually that concerned. So let me just close again in the spirit of someone said earlier, we believe in optimism with a little realism to it. So let's talk about ways forward. I think one key lesson here is that we cannot focus only on the latest institutionalization of carceral expansion, particularly mass incarceration and broken windows policing. That's an auto critique, because my book, Mass Incarceration at Trial, sort of really tried hard to say, look, mass incarceration is a terrible aberration, and at least left the impression that there was a kind of golden age of American corrections that we could perhaps go back to. And that's clearly bogus. If you think about the things that are mostly proposed as reforms, better use of parole, probation, risk assessment, those are all eugenic era tools that are fatally tainted by that. Secondly, I think we have to attack the myths themselves and not just the institutions, right? So the idea that crime creates a debt to society, where does that come from? Nietzsche wrote about that in the Genealogy of Morals and thought it might have come from the Roman law of debtor and creditor. But wherever it comes from, it's clearly an example of magical thinking. Most victims are not well served by the highly punitive state we have. Idleness is the cause of crime and poverty, which is the main myth behind the reform ideal since the 18th century. Idleness might be bad for people's mental health, but what do you mean by idleness? Slave owners thought that anytime their slaves weren't in the fields, that was idleness. If they were at church, if they were fishing or hunting and repairing their own infrastructure, that was idleness. Art was idleness. All those things are idleness. Most crime is the product of a dangerous, deviant minority. Well, now it turns out to be a deviant majority, or at least a big chunk of us, plurality. But again, once you examine the eugenic and biocriminality theses that lay behind this, I think it has little credibility. And finally, the idea that safe neighborhoods are aggressively policed neighborhoods. I did see one police car today here in Cambridge, but it strikes me that places like Berkeley and Cambridge do pretty well in terms of public safety without having a massive police presence. And finally, and I think this is consonant with what I've been hearing in many discussions today and on this panel, if we're really focused on abolishing the prison industrial complex, and this is nothing to add to what abolitionists have said about this, it has to be part of a broad social justice, racial justice agenda that really insists on upending racial capitalism. And that's why I think the most positive thing that's happening in the Golden State these days is not care courts or turning San Quentin into a Scandinavian style rehabilitation prison. It's the reparations task force and a political process that seems likely to make something like reparations a real part of California policy in the near term. With that, I'll stop and hope we can discuss some of these issues.
Thank you all so much. I have some quick questions for the panel, but first I just have to share the most embarrassing confession that a moderator can share, which is that my phone battery has died, which means I have no idea, Jonathan, if you went over time. Sunday, I will need help making sure that we end. Otherwise, this panel will just last forever, which maybe would be wonderful. We can just never leave this discussion. I have one question each for each of you, and then I want to open up because I'm already seeing folks' hands. Jamelia, this is maybe like the 50,000 foot head question. I would just take advantage of the position you are in your talk is as sort of this bridge between these two, both fields and systems that sometimes get siloed in literature or in teaching. We have courses in literature and scholars of disability law, courses in literature and scholars of the penal system. But to ask you how you, as someone writing at the intersection, think of the relationship between these two, because sometimes we hear them talked about as almost this like hydraulic type of thing. You know, this is the argument that the deinstitutionalization movement was followed immediately by the rising mass incarceration, and that if you manage to push down on one of these systems, it's just going to come up somewhere else. Sometimes it's almost that we talk about them as really just the same system, almost blurring the lines between them. Jonathan's point about them being interwoven. The more we think about carcerality as not just about incarceration, as incarceration, as these broader forms of state control, the more these just start to look like the same system. But then when I hear you and Jonathan's your different presentations, there is something that feels meaningfully distinct about them and maybe valuable about talking about them separately, in that, you know, he's mapped out these 5 rational myths, and they are distinct narrative legitimation put forward than the pity or the medicalization, you know, especially the pity piece, right? And it's almost the opposite of how we think of people who we condemn. So I'm just curious, as someone writing, you know, in the intersection of these, how you sort of put this all together and how it hangs together in your head.
I appreciate the question, because I think it's difficult as someone that is thinking about the interrelationships, you know, between, let's say, the criminal legal system and something like guardianship. I'm looking at categories across the silos that are areas of law, right? The artificial distinctions. And I think in many ways, it's sort of to Jonathan's point that, and consistent, I think, with maybe an abolitionist methodology. I think if we look at the logics, we can understand how the category of disability plays different roles, whether we're talking about criminalized disabled subjects or disabled subjects that are labeled in crisis, conservative ease, right? I think that in many ways, the logics, like what makes these disability categories so sticky and so productive and kind of rights deprivations or as sites of either exploiting, you know, an economic sense or expansions or justifying state expansions of power, help me understand, right? So the ways of the models of thinking about disability come from disability studies, but then we can also think about sort of a racial capitalist critique to understand the ways that categories of difference along racial lines can further a capitalist end. I can also think about disability studies scholars who have thought about racial capitalism and added disability to it. And so I guess what I'm suggesting is that if I'm thinking about disability as a category across these areas, I'm pulling from different insights to understand like what work disability is doing to marginalize, what work disability is doing to deprive. But it's not to suggest that these institutions are functioning in the same way or towards the same end. Like that I think would be overly simplified. And I think that the challenge comes, and I think why the erasure happens often, let's say in a criminal law course and a criminal procedure course, is because perhaps scholars have bought into these rational myths, right? There's an understanding, for instance, at the start of maybe early reforms after the racial reckoning uprising started calling for, you know, treatment, not cops, and right, the solution is hospitalization, which directly infringes upon disability rights and justice movement goals, right? So the goal is not hospitalizations, it's like treatment in your home, in your community, peer support, intensive supports. And so, you know, that becomes like, you know, the reform to, you know, defund can also contribute to, you know, the kind of diminution of the rights of people with disabilities unwittingly, right? Like just unbeknownst to some of the advocates, but then more education comes. And we start to sort of recognize that, you know, if we don't consider disability, then our criminal law reform or transformative abolitionist goals will actually undermine the goals of movement goals of people with disabilities. And so I guess for me, I also look to movement. So the Harriet Tubman Collective has weighed in on this particular topic and tried to contest criminalization. And again, naming hospital spaces as carceral, not because people who are, you know, charged with crimes or accused of crimes are there, but because the function of these, locked psychiatric facilities are sort of similar to the kinds of functioning, the functions that we see within carceral spaces in the criminal law context, in the sense of, maybe the kind of total institution Irving Gorman, the Goffman sense, right? So again, the similarities are there, but it's not like, of course, it's not to collapse the various statuses across these sites.
Thank you so much. By the way, if either of you ever just sort of any three of you want to jump in on anything anyone else has said, please feel free.
Yeah, I think I totally agree with what Jamelia said, and I also want to just highlight from the historical perspective. I think we're still in the aftermath, if we can call it that, of eugenics. And so eugenics provided a very coherent framework for bringing together mental illness, immigration, crime. It was all part of an inherited sort of racial unfitness and disability in that sense. And so we put women in asylums and sterilized them, we put men predominantly in prisons. We cut off immigration and try to deport as many people as possible. I think part of what we've seen since the 50s and 60s is like these systems are no longer yoked by a coherent ideology. And so we are, but I think we ought to be adverse to buying any easy narrative. One narrative is that we shrunk the health state and built the prison state. Well, you read Armando Lara Milan's book on how hospitals and jails sort of coexist with each other. They're very much, it's part of a comparable legal and fiscal system. Or I think we have to resist the narrative that deinstitutionalization was a disaster that led to the prison crisis we have now. That feeds the idea that we can never decarcerate. And there's a lot of work suggesting that while there surely were a lot of things that could have been done better, et cetera, a lot of people were decarcerated and not decarcerated. And we just have to be careful at how tempting it is to grab onto that, because it does lead to care courts and similar structures.
Jasmine, can I ask a question for you? And that one thing that struck me is sort of jumped out reading your paper alongside the others as a notable difference is, Jonathan talks about the big shift in criminal law away from private enforcement and away from private actors as the drivers. And it really jumps out. I mean, you start by grounding in your history, saying we should think of conservatorship as first private law. And even today, the examples you're giving are both within individual families and then this sort of corporate business of conservatorship that has grown out. I'm just curious if you could sort of say more about how you think of the relationship between basically the law of conservatorship here and the sort of the private actors that seem to potentially be driving it in a way that is different than when we talk about mass incarceration in the penal system, where the state looms so large, or where it's Eric Adams and Gavin Newsom. How are you thinking about that relationship and how, what law is doing to these private actors or the spaces it's opening up for the type of extraction from the people that you're focused?
Yeah, I think it's a great question. But I also would kind of reframe it slightly if I can, which is to say, I think there's a lot of the same work that's being done in the criminal space and in this disability space and the conservatorship space by private actors, specifically thinking about private equity in these spaces and the ways in which the laws around private equity ownership in nursing homes and congregate facilities has allowed for greater movement in that arena, right? And so you get the COVID situation that makes nursing homes look a lot like prisons, right? And so we've had these connections that we're able to kind of, these dots were able to connect in a meaningful way. So I think that the work of private law is actually quite a bit. And I think the foundations are historic, but I think what we've seen in the last 15 years, just in terms of allowing for a business model that, quite frankly, I see things like prison labor along the same lines as sheltered workshops for people with disabilities, and they're often owned and driven by the same company themselves. And so I think, I actually do think that there is significant overlap. And if we begin to look at it as this is through the lens of private law, as opposed to the state running things, I think it gives us more insights about that extraction and the level of extraction.
I saw at least one hand in the room. And anyone who's got comments, could you raise your hand high so I can see how many we have here? Great. And when I call on you, could you please say your name and introduce yourself to everyone? We'll start here.
Hi, my name is Yael. I'm a postdoc at the law school here. And I wanted to ask you, this is kind of a follow-up on your first question of the distinction or connection between the similar and different fields of law. It seems like what both of you two were saying, the first presentations were saying is something along the lines of Professor Robert in terms of child care protection system or policing, family policing system, is that we have a problem with the way we perceive protection, right? Protection is problematic as an idea, and this can go. I thought what I could understand from your presentations is something along the line that since the commitment of the welfare states in the US and generally in the Anglo-American model, right? If you think of the model of the welfare state is only to the needy, right? We only protect those who don't have a choice, who are not, able to help themselves, kind of thing. This is problematic because we're putting them in this space. And it seems like the alternative is problematic from all the reasons you said, but there's a lot of agency in all these myths. There's a lot of, these are people we're afraid of, or we want to change their behavior, or all kind of things, but they are very much agents of their own choice and will, and not only victims that that don't have a choice. And it seems like a catch, like how do we get away from this catch of these like dual perception of choice and agency, and what's a better treatment?
I will say that's a really interesting question. I mean, the piece of it that is jumping out at me, or it had jumped out at me. I'm going to maybe defer to you all. What I was about to say, it's there. It'll come back.
No problem if I could jump in just for a minute. When you think about framing it in terms of agency, it's fascinating because one of the intellectual moves and the disability rights frame and disability justice frames to kind of normalize the fact that we make decisions collectively. Right. And so you have these entire systems like guardianship and conservatorship that are built around this presumption that people make decisions independently. They do so exercising individual agency. And if you stop for a moment, and I often do this with my class, which is take a major moment in time when you've had to make a major decision to buy property, to buy a home, to go to college and make that investment, you start to dissect it and see that there's a collective decision-making structure built in, but for people with disabilities, it collapses, again, for the reasons Jamelia and Jonathan were saying. So I think this, and it's not coming at your question directly, but I think you did ask to reimagine a different model away from agency. And I think principally, we have to move past this notion of kind of the individual actor and see the individual actor as problematic.
To jump back in, I remember now what I was going to say, which is that in our criminal law jurisprudence and in our teaching, we do make agency seem like the be all and end all of criminal law, right? Deterrence and retribution are sort of signal things. And certainly retribution resonates with the notion of repayment and debt, et cetera. But if you look at the other myths, the ones that are more associated with modernity, like eugenics, like removal, like racial threat, they're not so tied to agency, right? I mean, the eugenicists thought it wasn't your fault that you had bad genes or bad inherited traits. Rosens thought we shouldn't even punish people. We should put them in essentially asylums to remove them from society. Even the modern sort of broken windows policing thing isn't so much about the agency of people, it's the social effects of what they're doing, right? It might not be their fault, right? Ray Kelly's defense of stop and frisk, right? It's not about who's bad and who's good. It's the effect it's having on the whole population that they're not carrying guns because they're afraid they're going to frisk them. So I think, we bring out agency when we want to legitimize criminal law in a certain way, but we also rely heavily on the idea that people aren't in control, and that's why we have to coercively manage them.
Just maybe a couple quick comments, because I find I'm often like trying to translate the different worlds. So Jasmine's point about, thinking about what disability rights movements have said about choice and agency. So now disability justice have sort of challenged that. So one of the things that they do is contest the myth of independence, right? So they're going up against these notions that we need the state to intervene and protect so that individuals can live independently, right? So it's a big cornerstone of disability rights movements. And one of the reasons they do that is because they're saying that in reality, we should be focused on interdependence, because that's the mode of living that, if we were to be honest, in the same way people, don't make decisions by themselves, right? So interdependence becomes the goal. And so I think that one answer to thinking about the ideal world and is that people are organized on the ground thinking through these questions. And it does harken back to this era of, the protectionism and custodialism that was at the height of eugenics and institutionalization era, that sort of myth that's then disrupted by disability rights and movements for independent living. But now in this era, it's interdependence, right? Because the state has failed us. There's no, ability to kind of promote on an individual basis human thriving. We should do that in communities. And so I'm again gleaning this from the mutual aid societies and movements that are kind of contesting these sort of terms that we've so easily relied on to justify state intervention.
There's two questions in the middle. Before I call, I have learned from almost 10 years of teaching that I always disfavor the left side of the group. Particularly commenting that, yeah, you're blocked up in the speakers. I'm just gonna poke for a second and see. Okay, great. In the black coat, will you tell us your name?
Hi, Samantha Goffin. This was a phenomenal panel. Thank you so much. So I think one of the most fascinating strands that maybe comes through all three of the papers in different ways is that when we legitimate control over people's bodies, custody of various sorts. And we're not in the restrictive opiate mode. We tend to use this very paternalistic error model for disability exceptionalism. And as well as the rehabilitation with the person, and although it's much stronger in the disability case. So what I think what's interesting about this in part is that it seems it's the narrative that works to justify the carceral state is basically a medical narrative, or a medicalized at least narrative. Well, there's an interesting tension with another strand in contemporary liberal ideology, which is potentially conservative one, which is deference to scientific authority as sort of our primary mode of engaging not only with questions of fact, but questions of policy. So this type of deference might be great for climate policy. But when it comes to the policy of managing people's bodies, we seems to still have in embracing this mode of thought, have really sort of given punishment and quasi punishment to another leg to stand up. So my question is, do we need to rethink the sort of that not deference to science, but deference to institutional scientific authority as the sort of dominant literal epistemology of how we ought to make policy. And so how would you articulate that problem and what we might do about it? And relatedly, because our error models for disability and maybe for prisoners generally are so often plated with say the mental age of 11 is a phrase you're seeing in the court documents. The notion of legitimate coercive paternalism over children and perhaps to a lesser extent, but still basically over elderly people. Or sort of like the other two exceptions. And I mean, you know, they are in some ways the less deeply controlled one. So I'm also curious to learn, like, if in some way court is like state back paternalism is part of what's going on with this discriminating narrative. Do you have an account of when paternalism becomes normatively legitimate, or what would normatively legitimate paternalism? Or is paternalism in general a problem? So like, and that's a compound factor that applies to all three, but yeah, just amazing now.
Thank you. Great. 2 questions. Science epistemology and the legitimacy of paternalism as the 2 branches. Anyone want to go first?
It's a fantastic question. I mean, it truly is. I have to go back to saying that I think there are lessons for how we think about this in the disability space, because the construction of expertise and the kind of pushback against medical expertise has been one of the through lines. And in particular, so getting back to the L and LPE, when you think about things like disability rights through the Americans with Disabilities Act, even something that is premised on pushing the boundary in terms of rethinking expertise firmly roots in it medical expertise as the form of persuasive evidence, as the form of probative evidence of disability, and essentially codifies this type of expertise. And so I think, you know, it's not, I'm coming at your question to kind of bring law back into the picture and say, you know, even these places where we think we're being absolutely revolutionary, and probably folks in this room don't buy that at all, right? It's a revolutionary space. But we need to kind of point that out, because the whole foundation of disability advancement has been through codifying medical expertise.
I really appreciate the question, because it's inviting me to think through like some of the like difficult questions that often come up at literally at the intersection. All right, so I'm thinking about the sort of justifications for police involvement in crisis response that you most often see in the law, and that in many ways come through, sometimes justified under parens patriae. The most iconic example is suicide prevention. And so it in many ways is that an individual in doctrine, it sort of is the police have to come in to save a life. In reality, that's one of the deadliest encounters a person in psychiatric distress could face if the police show up in their crisis. And so I was pushed to sort of look at the history of suicide crisis response, because I'm trying to get to the depth of what are the logics that are justifying the potential force, physical force, deadly force to stop someone from taking their life. And I'm reading this book called The Power to Die, and it talks about how the earliest suicide practices are the period of chattel slavery, right? To try to save enslaved people from taking their lives. And so I want to just like sit with the graph that the height of state violence, racialized state violence, is the period when we develop the innovations around suicide prevention. So I'm thinking about that in the kind of the sort of thread of paternalism, right? And the violence of paternalism. And so to your question is like, when is paternalism legitimate? I'm working toward its legitimacy, because I'm sort of trying to show the height of its legitimacy, right? The justifications of preventing that act, right? We see that its origins are tainted, and that troubles me. And so I also, you know, looking around the room, and many of us are Black feminist methodologies, right? And thinking about how ways of knowing can be used to disrupt these narratives, to push back on the paternalism and Gozi and yeah, like this is the work, right? And so, as Jasmine said, disability rights and survivor movements, which we often don't talk about in the abolitionist sort of deinstitutionalization abolitionist movements, they've relied on it, right? Yes, as a person in crisis at that point, capacity is diminished, right? But in prior points, there can be statements as to how I should be treated when I'm in the point of crisis, right? And so there's ways of building in agency to these processes. And in any event, if you look at the disability justice groups, they're saying one has the right to remain in crisis. And indeed, if we go back to the colonial era, there was a certain amount of wandering in crisis that was permitted as part of the rural agrarian, yet still conceived of as orderly society. And so again, we're really pushing how I think many of us think about disability, even those that study it, like these are radical ideas and I'm hoping, that maybe the authoritative way I'm conveying it doesn't suggest that I have all the answers or I'm fully convinced either. I'm learning alongside these movements. But I think your question is a really profound one because it implicates questions of state power. Because again, the legitimacy of these, like the blanket intrusions into people's homes, warrantless searches, which I'm now studying under the Fourth Amendment, like the justification are paternalistic, right? And so for that, we deprive you of rights under the Fourth Amendment, right? Just to help save you, to care for you, etc. So yeah, thank you for the question.
Just really briefly to add on to this really interesting strand. I mean, Jamelia reminded me that parents patrie, I think translates as the king is the father of the nation,
Right.
As the origin story of that power. So I guess one answer would be democracy and rights. I mean, if it's still the king that's taking care of us, obviously that has a lot of bad stuff associated with it. I completely agree with you more that the history of the carceral state has been deeply entwined with medicine, going back at least to John Howard's state of the prisons, which was all about jail disease and also saw crime as a miasmic disease that could be cured by removing people. What's interesting is how in America, at least, police and even more so prosecutors have taken control of the expertise narrative from the doctors. In Europe, there was a pitched battle between the doctors and the lawyers over the meaning of criminology and whether we were going to have a legal system or a medical solution to deviant, dangerous people. But in our country, it's prosecutors who've been given enormous discretion to decide who's really dangerous. And that leads me to one of my favorite sort of, and I'm going to have to paraphrase, but one of the big problems with being an abolitionist is when people come up to you and say, well, what are you going to do with the dangerous few that are locked away there? And Mariama Kaba, has a two-part approach to that I like. One is we're going to chip away at the concept of dangerousness because we know that it's freighted with tons of racialized meanings, et cetera. But then we're also going to accept that it's a collective responsibility to address what's left. And we can never really rely on a separate institutional domain to take that ethical responsibility off us, whether it's medical or legal.
If I could just quickly add one other point, which came to me, it's this beautiful concept in the disability studies literature called the dignity of risk. And so this notion of, granting someone the ability to remain in crisis, at least conceptually, is a beautiful thing. I get that it's problematic for perhaps other reasons and raises questions that we ought to be concerned, care about this individual, but at its core, the dignity of risk.
That there was a hand in the middle here. Sorry, did you just have it? I thought I saw you raising your hand.
I did, it's too big a question.
Yeah. Maybe you would better sense of how much time is left than I do.
Yeah. Inspiration. Slipped away, political economy slipped away. There was a group, and this is chiefly, but not entirely directed at John, and it can be for another day. But I was simply struck, in virtue of being in a long political economy gap, that political economy did a lot of work in the early stages, in the birth of the penitentiary. But a lot of the rest of the work, to use just shorthand, is more political than political economy. Or at least that's probably.
Yeah, no, I wouldn't agree with that. I'd have to put back up my slides, but I can take you. I can take you through some of the local economy, right? I mean, you have to understand the eugenic moment as a tremendous local economy moment. It's globalization round one and the global superpower competition between Germany and Britain and the US to see who would be the racial superstate. And that had direct economic implications. Read Thomas Leonard's illiberal reformers on how much American economics was all the way in with eugenics, including your buddy Eli, whatever. Britain, yeah, who was deep into eugenics and believed in it passionately. The post-war mass incarceration moment is all about the crisis of urban real estate and mass private property in the cities. And the University of Chicago and NYU both consider leaving to the suburbs because it's just not viable to attract middle-class students to these, permanently dangerous cities. So the reclaiming of cities, is very much the issue that Gilmore brings this up. The threat that poor people are posing is no longer to steal things from department stores. It's to lower the value of downtown just by their physical proximity to it. So yeah, I think political economy remains really important, but we want this is the Durkheim part as well as the Marx, is that it's not just the current relationship of the carceral state to capitalism, right? I mean, what does the tech economy really care about the police and the prison system? It's this long arc of meanings that have been, invested in the punishment process by earlier moments that give this such a tremendous legitimacy today. That's what I take.
Sanjay, can I check with you on our time?
We have time for one more question.
Yeah, did you want?
This was the same question, just a little less, I'm just trying to dig it out from things you were saying, because I think it's, so Jamelia, about 2/3 into your presentation, you talk about the shrinking of the welfare state and its relationship, and tying it to the emergence, and Jasmine, you talked about racial capitalism locating specifically the guardianship within the framework of dealing with this anomaly of a free Black person in a society that depends on denying it. So it's more of a question of what do we do in terms of method, presentation, to integrate these analyses into a theory of political economy, because you could argue Durkheim versus Marx, but even before you do that, your response is already to then surface these particular questions. And so the consequence of the shrinking of the state that's part of the agenda of privatization and deregulation that's so central to neoliberalism. So I guess this is more of a partly a question, partly a comment, because in each of your presentations, in my ear am already hearing it tied to a particular regime in capitalism, to a particular moment of transition, to a particular set of crises, with a particular set of subpopulations. You're talking about eugenics partly in that context, but it's partly also beyond the globalization. It's just a massive immigrants and the high density produced precisely to create an exploitable underclass that then triggers the reaction. So it's just a question of more of how we think about how we surface these questions as an integral part, and what their relative salience is in our presentations, prioritization of which components go. But exactly the same question of the greater connection with political economy, the more explicit, not greater.
Can I make a motion that we add Durkheim to the list of political economists? After all, his most famous book is called The Division of Labor in Society.
We can't close in a minute.
I will say one thing, which is, I think what is common in the thread that you can pull through, and there are many threads, but the one that I hope people in the LPE community leave with is this notion of disability exceptionalism, which is, you can call the category what you want. There is a carve out for some class of people that will change and shift over time. And we can put people in this category and take them out, and they're malleable. And the danger around disability exceptionalism is that we keep it at arm's length, is that we believe that it is a legitimate category of regulation. We believe that there are some group of people for whom the state should be involved in their lives. And it's always been that way. And I think the danger here is to keep that category alive and well without interrogation. And so my hope in being in this group of thinkers and doers and in this environment is to understand, again, surface those moments. But specifically to say, here's this category that we keep closed, we keep behind closed doors, proceedings are closed, contrary to our public nature of proceedings, right? It's the anti-Bentham model when it comes to disability. Disability is the exception to everything. And so because of that, it's dangerous. And I think if we can, as a community, think how that slices, whether we call it Durkheim or not, is a whole nother conversation. But I think having that on the table in this is important.
Okay, I really appreciate the question, and I'm just gonna go into real talk mode for a second. So I'm here because I want to engage with the discourse political economy. I'm a critical race theorist. And when I hear discussions within the LPE space that sort of talk about dynamics of race and gender, I sort of wince a little bit. I'm wondering why that's not integrated at least into the analysis. With Angela Harris sitting here, I have to say, Angela Harris taught me racial capitalism through the CRT lens, then LPE. And so the question, I think, the work that needs to happen in bridging these divides, I think we have to authentically show up as crits and maybe studying race, as law and feminists, femcrits. When I think about who taught me political economy to CRT, it was Bob Chang towards Asian American critical legal or critical race studies, something to that effect. It's in the Cal Law Review. And so the analysis was sort of shown to me without laying out the tenets, without telling me exactly what was happening. And so I think it's a really fruitful space for us to start bridging these divides so that the identities and the categories that, as a critical race scholar, disability studies that I care about as well, and an analysis that quite frankly I'm comfortable with, can be integrated seamlessly into these discussions. So I greatly appreciate the conversation and hope that we can try to bridge these conversations a bit more. Thank you.